And once you're in bed with someone, you want to make sure.
That's kind of how horse trading and contract negotiations happen anyway.
You soon learn that you need that experience in the room.
You just need that massive cash injection.
What do you both do to ensure that you're like getting in the heads of that founder?
A lot of it comes down to sort of really like war stories.
I absolutely can't live with this risk.
Transactions aren't risk-free, not for either party.
What am I looking for? Just absolutely terrified.
I don't think we come across as intimidated.
I'm Shona Grundy, founder and host of These Three Things, a podcast aimed at building a thriving and more inclusive startup ecosystem through sharing real lessons from people doing the hard work. We focus on the three strategically critical aspects of the startup journey: raising capital, finding product market fit, and expanding offshore. If you find this useful, please subscribe and recommend the podcast to at least 3 other people. We appreciate you lending us your ears and joining us for this episode. Today we are joined by Edwin, Lim, and Calvin Luo, who are corporate and commercial lawyers at law firm Hudson Gavin Martin, or HGM, in Auckland, New Zealand. HGM is a specialist technology, media and IP law firm that acts for both technology vendors and customers of technology solutions. Calvin is a senior associate and specialises in corporate law and has extensive experience in private equity and venture capital mergers and acquisitions. He advises on corporate transactions such as business, sales and acquisitions, corporate restructures, capital raisings, joint ventures, shareholder agreements and employee share schemes. Ed is a partner at HGM and has both an IT systems development and legal background, so his day job involves advising clients on legal matters as well as looking after HGM's technology infrastructure. So in a way, the CIO of the firm, which he enjoys just as much as helping his clients. Ed has almost 25 years experience in helping customers of technology to procure tech solutions, as well as helping technology businesses grow, as well as protect and commercialize their product. I also have had the pleasure of being a co-judge with Edwin each year on the New Zealand High Tech Awards, which is a fabulous experience. I enjoyed that very much. Let's just kick into getting to know you both. I explained to you earlier why we want the professionals from our industry here. It's very much this relationship that is being built around the CEOs and founders, which have a very high profile in the industry. But I can, tell our listeners right now that they are being heavily supported by professionals such as yourselves. And, your learning and expertise is just highly important. So I wanted to start talking about who those professionals were and what they do and why they exist. So I'll start with you, Ed. How and why did you enter this field?
Sure, it's good to be here. First, also thank you for inviting us. I ended up in this field kind of slightly by accident in that I did a Bachelor of Commerce degree in information systems, so I was always going to be I thought an IT consultant or a developer. But as you do, back in the day, I was kind of wondering what my friends were also doing. They were doing a conjoint. A lot of them were doing it in law. So I thought, I'll just do that because I didn't hang out with my friends. So I ended up, after 6 years at uni, with the Bachelor of Commerce degree and a law degree. And I thought, well, what am I going to do? Am I just going to go down this path of sort of wasting my law degree, but having a really good opportunity to go into the IT field? But I was fortunate to get a summer clerking job at one of the large law firms, Bell Valley, and I started there in their communications technology and media team. And so I've been doing law and IT, or law and technology work since then. And some of the partners there set up Hudson Gavin Martin about 7 or so years after I was there. So that's how I got into it. And the beauty of it is that I understand all the technology, the acronyms and the language, as well as the law, and that's what excites me.
I'll take it back to a conversation I had earlier on another podcast where it's about getting to know your customers and deeply understand their problems. And so I would say that profile of actually, being trained, in IT like you're very hands-on and being able to understand where they're coming from and the world that they're living in. So, it's really relevant experience.
Absolutely, and especially when a lot of founders that I deal with are not necessarily, they don't have the deep technical expertise, and that's absolutely fine. It's the person that comes up with the idea and can commercialize it and then build something great from it. And so I'm able to help them to navigate the technical issues, the commercial issues, as well as the legal issues. And that's what I like about my role, which is I'm not just a legal advisor. I can talk about open source and how that's important, to how do you deal with that in your products and why it's important. What are investors looking at and what are people who are buying your business looking at in terms of, say, your open source, and how does it fit within your product?
Calvin, I'd love to. I know Ed a little bit more than you. I've met you today, which is wonderful. But could you give us
Yeah, sure. First, thanks for the introduction, Jonah. My path was probably a bit more straightforward than Ed's, but did a law degree conjoint with us at University of Auckland. Had a summer clerkship at Minter Ellison Rudd Watts. Originally, I was I thought I wanted to do litigation, but there was an opening in that firm's corporate team, so I took a chance and took a stab at corporate law, and I've been doing it ever since. Starting at Minter Ellison, I moved to Chapman Tripp, where I got to work with a lot of VC firms and private equity firms that kind of are investing around our region, and moved from there to HGM. It's kind of an interesting dichotomy there, because moving from supporting the VCs and the private equity funds to kind of being on the other side, supporting the startups and the founders.
So you would have like this really deep understanding and background of what the VCs are looking for, which is always the $1 million question for founders, right?
I would like to think so, but you never. I guess some days you just never know. But yeah.
The landscape does change.
Exactly.
Before we jump into these three things, we're going to talk with you guys today about your particular expertise in both investment and going offshore, which is, really your strengths. I always like to talk about what the purpose is of something. So, you're commercial lawyers, you have this specialty, you help your customers. I'm sure you're very sure of your purpose and why you exist. But I think there's like this hidden veil over what legal help is, and we see it only from a movie point of view, or this perception of, what your job is. Are you able to explain to the listeners what your purpose is and where you bring your value?
I think, I'm probably showing my age here, but it's not necessarily like LA law or suits. It's not like you just rock up to another lawyer's office, which you see in suits, and they do this deal, and the lawyer is a litigator, is a M&A lawyer, does everything. We're quite specialised in what we do, and I like sort of my job because I get to help people to ensure that they are protected, that their risk is mitigated, and to help them to grow. Like, my view is to create a really long-standing relationship with the client. And I've got a number of clients who I've started off with, and I've taken them right through to an exit. And unfortunately, you lose the client then, because the client is then purchased by somebody else. But then I've got the founders who I'm still, good friends with. Like, I just caught up with one of the founders that I sort of worked with just over the last, 15, 18 years from ProMap. So I just caught up with him the other day. It was just good to see him enjoying life and, just come back from a holiday. But
is he one of the exited founders?
He exited from ProMap. He sold to Nintex in 2018. That's what I like. It's not, we don't see ourselves as stuffy old lawyers, because we're at that kind of age where we like tech, we like dealing with people and helping them. I don't think we come across as intimidating.
Well, I hope not. The fact is, we would love to be certain as to what our roles are, but the role of lawyers has kind of changed over the years as well. It's gone from a more of, I guess, from more the traditional sense of I'm in trouble, I need help, thing to kind of being an overall kind of advisor for the business. As it says, we're involved in more general aspects of the business rather than just, sale, investment.
I picked up on you using that word risk. For me, that was always the biggest lever that I've wanted to engage with lawyers. I can't see all the things coming at me. One, I'm not sure what I don't know what I don't know. And I see, though a lot of people look at lawyers with any type of document or agreement, the lawyer will do all things around it. And so I've also seen founders where they just go, oh, well, I had this commercial agreement written up for a sales agreement, and they've done it for me. And I'll read through it and I'll go, but, it doesn't cover your IP strategy. The customer has full, they can take back their data at any time that they like. You can't use it for your machine learning program. You haven't covered these areas. And I know that's not a lawyer. That lawyer who pulled it together did their best work. But it's kind of the missing piece for me where I feel like a founder has, or the person who's doing the head of sales or something, hasn't clearly gone, this is my business model, this is my mission, this is what I'm trying to achieve, and just ask for a document to be made up. So to that end, what do you both do to ensure that you're like getting in the heads of that founder of like, what's their strategic objectives, what are they trying to achieve, that kind of stuff, to actually deeply understand what they want with their business?
Yes, I think it's really important to sit down, start, and understand everything about the business. You can't just review an agreement and say, oh yeah, this is what you need to put in. I like to sort of have a first meeting with someone. I like to have ideally a face-to-face meeting. I mean, obviously with lockdowns and COVID and stuff, it's been through Zoom, but I just find that it's so much easier to build that rapport with a founder, and so that they realize that, oh, actually you're just we're human as well, and we understand what your issues are, because we want to understand what their business is. We want to understand how their product works. A lot of people find it quite odd when I ask them, can I play around with your, say, SaaS platform or whatever it is, because I like it from a technical perspective, because that's what I do. Well, what I like doing, just looking around and seeing how it's sort of been created, and from that I can kind of work out what you need to do to, say, for example, protect your IP, or what terms and conditions you need, or you're collecting all of this data. How are you using that? What are you going to use it for? So understanding the product is really important, but also understanding the founder or the other stakeholders in the business. Like, what's your risk appetite? Because obviously there are people who will be happy to take on risk, and that's fine, as long as they know what those risks are. But there are some people who are also conservative. They don't want to take unnecessary risk, and that's absolutely fine as well. And so for me, it's saying, hey, look, you could do this, but in my view, I don't think it's a risk that you need to be worried about, because I've done this so many times, I've never seen any issue with it. Whereas at the other end of the scale, where you've got a person who's happy to take on risk, I'll say, well, actually, I have seen this happen before. You might want to do this to mitigate your risk, because there is a high chance that something could happen if you taking code from someone else's platform where you could have an IP infringement.
And what do you mean by like mitigating a risk? It's not taking it away, is it? But what are you doing?
It's not taking it away. It's just identifying what that risk is and how you can sort of lower the risk of, or lower the chance of that risk occurring or happening, right? So it's kind of like if you're driving a car, right? You can, if you want to lower the risk of having a serious injury or an accident, right, put your seatbelt on. So that's the sort of thing that we would sort of advise on. And a lot of it comes down to sort of really like war stories.
Yeah.
And just saying, look, we've seen this before, probably won't happen, you're probably fine. Or, yeah, we have seen this issue in relation to a restraint of trade. And, you might need to kind of consider whether or not this is actually appropriate for your shareholders room or whatever it might be.
Yeah, that's right. And it's kind of a two-way street as well. It's two-way conversation really, because yes, on the one hand, we can tell you, hey, here are the kind of risks that we kind of see here. But on the other hand, it's good for clients to tell us, hey, this is our risk appetite. We don't care if this XYZ happens as long as, A happens, just so that we can kind of give you more tailored advice. So as much as we try to understand your business, it's good to communicate what you would want us to know about you as well.
When I first started getting into legal negotiations, I think I was 23, and my boss at the time, he was he used to be the manager and producer of Judas Priest and Def Leppard and Eurythmics, and he was doing this big licensing deal to a record label, and it was a 100-page agreement, and he chucked it on my desk, and he just said, "Read that," and I was like, "What?" And he was just like, "Yeah," and I said, "Well, what am I looking for?" Just absolutely terrified. And he just said, "Looking for unusual stuff," and I just didn't even understand what that meant. And then finally I was like, and I was just reading, and back then it was like terrible language as well. And I have noticed that language in agreements has just modernized, and it's more about making things crystal clear. And he turned to me and he just said, we just follow the money. And it was just, it kind of like grounded me into my approach, right? Like I just went, okay. And he said, there's some creative things, there's some control things, there's different levers that people are pulling in a contract. He said, I care about the money, how we get it, how we get paid, how we stop the risk of not getting paid. And I was like, oh, so that to me was his clear. And it's kind of the path I follow now. But I watch some clients of mine. I don't work in the legal space, I do other stuff, but they will be terrified of every risk a lawyer will put in front of them. And so, what are you saying? Like when you're you're lining this up and going, have you considered this? Have you considered that? What are you actually asking them to do? Is like to mitigate all the risks, or?
Oh, I don't say it's mitigating all of the risks. It's just, looking at if the worst case scenario happens, what are you liable for? Is this going to bring your business crashing down? And so if someone comes to me and says, hey, Ed, I've got to sign an agreement today. I've got like 10 minutes to look at something. I'll say, well, the three things I'd look at would be maybe, what is the term of the agreement? Like, are you locked in? Depending on who you are, customer or vendor. The second one might be what sorts of, what promises are you making? What warranties or indemnities are you providing? What can you be sued for? And the third one will be, do you have a limitation of liability in there? So if it all turns to custard, what can the other side sue you for? Because if they can only sue you for the value of your contract, which is maybe say $50,000 worth of fees, then that's probably okay. But what you said before was quite interesting, was you said, looking at the contract, tell me what's unusual. Sometimes it's what's not in the contract, right? That is really important. So that a lot of the times, if you're a SaaS provider or any tech provider, right, you might be provided with the customer's contract. The customer's contract may not have anything which mentions liability caps, which means that if there is no liability cap on the vendor, then you have essentially unlimited liability. So those are the sorts of things which I would be sort of looking at in terms of mitigating those risks. There are other things like, if you ask me what was really important, but what I'd go on and on and on about years and years ago, it'd be like IP indemnities. When you're creating a product, your customer will want to know that you haven't ripped off somebody else's IP, and that if you have, then you're going to fully reimburse us or indemnify us if we suffer any loss because a third party comes knocking on our door saying, hey, you've ripped off our IP, or you're using someone's product which has ripped off your IP. To me, that's like, in my however many years of practice, I've only ever come across that issue in terms of being problematic maybe once or twice.
Wow.
Whereas what I'm seeing now is all around cyber issues, right? Cybersecurity issues, data breaches, those are the sorts of things that really matter. And so I'll say to the client, hey, look, your IP, yeah, you can give this indemnity and yeah, there is a risk here, but it's probably a low risk if you haven't copied anyone's software. The real risk that you've got today is, are you keeping your customers' data secure? Are you breaching any privacy laws or data protection laws? Or that's probably more something you need to worry about today.
I just want to pause here for a minute to tell you about our sponsor, Callaghan Innovation, Aotearoa New Zealand's innovation agency. This agency empowers innovators, helping you transform your world-bettering ideas into commercially successful ventures. What you may or may not know is that Callaghan have a fantastic suite of products called Upskill. These products will help you identify the innovation, R&D and commercialization skills you need to amplify and elevate your ideas, and then train you to put them into practice. So go check it out by heading over to their website, callahaninnovation.govt.nz/upskill.
Transactions aren't risk-free, not for either party. There has to be some kind of element of risk that you're willing to accept to be able to get a transaction through. And hopefully the reward of the transaction kind of justifies that risk. So if we give you a list of the risks that we see, you might ask us, hey, what do you think the level of risk is? What is the consequence? We'll tell you, and then you consider, okay, how likely is this to happen? And can I kind of deal with that consequence? And you kind of weigh that up against what the deal that you're trying to get through. Ultimately, we're here to advise, but ultimately it's for the owners, the shareholders, to kind of make that decision.
Exactly. And that ranking of risk too, I like that. I like that approach. It's like, I absolutely can't live with this risk, but I can go to sleep at night with that risk. And, what's the worst thing that can happen? X, Y, and Z, I can manage that. To get a contract across the line, right? Sometimes you just got to get the deal done.
And that's kind of how horse trading and contract negotiations happen anyway. You tell us we can't live with that risk no matter what. We'll go back and say that's kind of a hard line for our client. Yeah.
And it's being just totally pragmatic as a lawyer and understanding that, as lawyers, we do not make the decision for our clients, whether or not you're an external lawyer or an in-house lawyer. It's up to the business to make that decision. We're here just to advise on what the areas of risk are or how it should be structured. And I was actually at the SASTA conference last week in San Francisco, and there was a session there was a VC session, and someone had asked, well, what sort of lawyer should be working on these VC deals or cap raise deals? And the VC said, well, you need to have a lawyer who understands the business and how to get these deals done and doesn't basically nitpick on everything, because if you do that, no deal's going to get done and it's just a waste of everybody's money. And so I think it's really important to have a good commercial, pragmatic lawyer who's just not going to worry about absolutely everything, if you know what I mean.
100% agree with you on that. I kind of feel like I've gone through 20 years and I've got this profile or this personality type but that's through my learned experience of the type of lawyer I like to work with. But this one is like, they're pragmatic. They're like, you want this deal, I've got to help you get this deal. What's the fastest path to helping you get there? And they've learnt my risk profile as well. So they kind of go, oh, that's fine. Yeah, you can live with that. And they get to the chase. I've worked conversely with other lawyers that my boss told me I had to work with. And they were a 2,000 firm lawyer in San Francisco, and they redlined everything, and it was a nightmare, and things were in capital letters through the contract. So they were shouting at my customer in the contract, and they redlined everything, and it took 4 months of dragging that sack of potatoes over the line, cost us a fortune, probably as much as the contract value itself. And I just turned to my boss and I just went, never again.
Yeah.
No.
Yeah.
Yeah.
But that's like, it's like you just want to get the deal done. And it doesn't matter if it's on the back of a napkin or if it's like on, 20 pages of beautifully typed out, contract or whatever. It just has to be done in a way that everyone's happy. Like I will say to a client that, hey, look, I think it's just a waste of time by doing it this way, because your money is better used growing your business or whatever it is than trying to fight this particular clause. If it's not a massive transaction. So it's just making sure that you're aligned with what the customer needs. And sometimes you need to sometimes I'll tell the client, like, just don't go there. It's just not worth it. But that you can only say that through experience. If I was a first year lawyer,
Yeah.
I'd have no idea, right? It's only through years and years of doing this that you kind of know.
It's like anything, right? Like, the more experience you get, the more you can bring to the table.
Yeah.
And so unfortunately for the founder or whatever, they're paying for that, but you soon learn that you need that experience in the room, and that's actually what you're bringing to the table. Let's get on to capital raising, because I think that's why a lot of our listeners would be here today. Why have you seen that companies consider raising capital? What are they trying to do?
The number one reason is cash, but close second I would say is expertise. I guess to start off with, at the ground level, when you raise capital as a startup or early stage company, you have very little cash, but you have a lot of shares that you can give away. And when you give away shares, you bring people on board to become your kind of partners in your business. And with them, they bring cash, but also they can bring their expertise. So I guess it depends on the type of investor they're looking for. A lot of people want investors who can both bring capital and expertise. Maybe they're experienced investors in that industry. They can kind of get you connections and advice for that industry you're working in. Or they're happy with, just passive investors. You don't get any control of the company, but you give me cash and I'll give you good returns. That's kind of the promise that they have between them. So I would say cash and expertise, the two main things. Obviously cash, depending on what stage for the company, stage of business you're in, can fulfill different roles, whether it's for development of a working product or, for growth, for advertising.
I've seen a lot of clients who will just bootstrap and not seek investment. There is nothing wrong with not getting investment, right, and doing it. I know it's a lot harder, but there are a lot of companies here that fly under the radar who don't get investment, because obviously when you seek investment, you have to give shares away and potentially lose control of the business at some stage. But there are, if you, and I'm talking about sort of people who have been in, say, like business, they hadn't started off like just straight out of school type sort of thing, which we often see, but people who've been in an industry or been in business who are, maybe in their late 30s or 40s might start a startup, and they'll have a few, savings and whatever it might be to get them up and running. So in that case, they may be able just to bootstrap until they get their sales and them being able to kind of operate their business through that, rather than having to find an investor. Sometimes what we find is that investment is the number one goal, as in I'm a successful business if I have investment. That's not necessarily the case. All I'm saying there is that you need to just weigh it all up.
Cap raising is a means to an end. You have to think about what your goal is. Often we have clients that come to us and say, hey, we want to raise some capital. We just ask them, what are you raising the capital for? If you think your business can sustain itself, you can bootstrap for a little while longer, get some government funding, and then your business can sustain itself. You can kind of just get away with not cap raising and just keeping your control of your business.
And potentially building some more proof points, which adds value.
Exactly.
To when if and when you want to raise money one day, you're actually like, well, I have achieved these things now.
Yep.
I've proven to you how much value I give to my customers. So yeah, there is merit in that.
Especially if you're really early stages, then you can build your revenue, like financial history a bit more. Otherwise, you have nothing to kind of show your investors.
There's this like mysterious thing, and I feel like I'm starting to crack it, and I've cracked it, and I understand it. But there's this mysterious thing about the words that have been given to different stages of investment. So, pre-seed, seed, A round, B round, C round, blah, blah, blah. In your opinion, what are the definitions of each level of round, and what are they trying to achieve?
Okay, so it depends on what industry a business is in, but generally, if we start from the pre-seed round, so pre-seed, basically you're at ground level. We usually call it the friends and family round. Your second investment, probably relatively informally, from just anyone who will kind of like support your idea and will pitch some money in. Yeah, this would be friends, anyone you have a close professional relationship with, maybe. But this is generally before the VCs and angel investors kind of get involved. Maybe you don't even have a working product yet, and you need some funds to kind of get the prototype out there. That's generally what the money from the pre-seed round will do. And that hopefully will launch you into the seed round. You have a proof of concept or something, because that's what you use your money for, to develop. And now you can reach out to the angel investor community, the various VC funds around in the region, and kind of just try to raise capital, get to the next round. It's all about growth at this stage, really. And maybe in the seed round, maybe you haven't quite found your market yet. Yeah, it's kind of that intermediate kind of stage where you've got something. It's not as refined as you'd like it to be. So that's kind of where the seed money goes. The seed round is where a lot of businesses we kind of see initially approach lawyers for formal documentation, because that's kind of what the angel investors expect when they invest in your company. They'll have their terms. You want to document in a subscription agreement. It might be the first time where you get a shareholders agreement in place. After that, you have the Series ABC, or however many other subsequent rounds that you want. That will be when the business is relatively mature, has a solid track record, and want to raise money maybe for acquiring other businesses, or whatever your goal is. Maybe your goal is to work towards an exit. It will just be kind of ways to expand the company, in terms of services, products, maybe geographically. That's kind of what the Series ABC rounds are for. Yeah, so the subsequent rounds after the seed round is A, B, C, all the way to whenever you kind of exit the company.
Yeah, a lot of times it's around scaling or hyperscaling, right? And just taking your product to totally the next level.
Yeah.
Where you kind of need that, you just need that massive cash injection.
And coming back to the previous point, actually, if you don't need the funding after the seed round, maybe this business is very successful. A lot of businesses just don't do ABC, whatever rounds of fundraising after they've kind of become self-sustaining, and they can kind of just grow organically towards maybe an exit or wherever you want to go.
Yeah, we've worked with a gaming entertainment client who did a funding round, and they've stopped funding because they stopped seeking funding because they are doing so well in terms of their revenue growth over the last few years that they just don't need to get additional funding. So it's all just working really well for them.
And that's probably when businesses can then leverage the Callaghan Innovation Fund, because it's often match funding, right? That's often the confusing thing for founders. They're like, okay, so I can get $50,000 off you, but I need to have $50,000 first. They're like, but I need that money. But I think that's what they need to consider as soon as they raise that investment. It's like, well, how can you actually leverage that to create more value and more opportunity, and with NZTE and Callaghan and even debt financing, a bank will be more open to your risk profile on that, wouldn't they?
Yeah, they would be, because they can obviously see that you've got, if they look at your books and you've got revenue coming in, so it might be easy to, say, debt finance for like certain projects, if you know that we'll be able to sort of pay that, debt off in a short period of time. And obviously you probably don't want it hanging over like a mortgage on a house sort of thing. But yeah, there's like other funding available, like you mentioned Callaghan or NZTE, and various programs through Callaghan, for example. There's a Beyond IP program, which we're providers of that, where for a technology company or any company with intangible assets, so they're about to commercialise, then they will fund up to 40% of your legal costs, up to $10,000, right? And so that's actually not bad when you think about you getting $25,000 worth of value, and what you put in is, say, a maximum of $15,000. And for that type of fund, you don't need to actually just come up with or commit to $15,000. It's basically whatever is spent, right? Or whatever is incurred. So if you only have $10,000 worth of legal fees, if you like, then Callaghan will pay, maths, $4,000 of that, and $6,000 is paid by the client.
Right.
So yeah, there are other ways.
Yeah. And to kind of add on to that, mentioned onboarding new investors, government funding, short-term debt funding from banks. After you've kind of reached the seed stage and beyond, you might have a wealthy investor or two on board as a shareholder. So the first avenue of further funding that we see in a lot of those companies, it's just ask your existing investors and say, can you inject more funding into the company, maybe issue new shares to them, or you can ask them for a shareholder loan. Various ways to get that funding to take you to the next level.
I was just thinking back to your comments about why you might want to get an investor involved. They're bringing in not just the cash, but also the expertise. That seems to be a thing that I've seen a lot of founders think, this will be great. They'll be able to introduce me to customers. They'll be able to advise me, all these sorts of things. But the reality is I don't see a lot of that going on. There are shareholders, they're just shareholders, and they're just putting in cash as a bit of a punt, and they don't have time to get involved. Is there sort of any examples of when you've experienced where the match isn't correct? There was expectations on the investor's side and expectations on the founder's side that just didn't match, and how could they have avoided that, do you think?
Absolutely. And I think it's really important to do your own due diligence on your investor. It's kind of like, if you you get married, you're gonna you want to know who you're basically getting into a relationship with, right? And so you sort of go through that kind of courting period, but you want to know who they are. And I think in a number of cases that we've worked on, it hasn't gelled out. The people haven't gelled properly. But sometimes it's a little bit too late, because the investor has already put in a certain amount of money, and they may have quite a maybe not a big chunk in the company, but enough to sort of have some kind of control over the business. So I think it's really important to know who you're dealing with. And got a couple of war stories here, right? And we've had, just in this last year, we've had investors who have said, I have absolutely no idea what your business is, but I'm willing to sink all this money in your business. The founder is really excited because someone's really interested, and we've said, is this the right thing to do? Is it too good to be true? Because if it sounds and smells like it's too good to be true, it is. And we've had that, I think, 3 times now.
Wow, that's quite a lot.
One was a type VCP type firm.
What's a VCP?
A venture capitalist or private equity firm who were going to put money in, and then when they found out when they did their due diligence, actually they were reading the shareholders' manual or whatever it was.
Yeah.
Then they realised, actually no, we didn't understand this or didn't realise this. We're going to pull out. And, that was a lot of time and money wasted.
The problem was that they did that at a quite late stage in the investment, so it incurred quite a lot of cost already for the founder. So that was not great.
With that in mind and thinking about risk, was there any way up front that a founder could have said, we're going to share the costs of this? Or, because going into an investment round, it is going to cost you money and you need to set that aside because, I think if there's one thing that you don't want to do on your own as an investment raise, it's just, it is your baby, it is your marriage. And once you're in bed with someone, you want to make sure. But was there something they could have done to prevent that?
I suppose in terms of what we see is obviously the investors will require a certain amount of the actual legal fees for their side to be paid by the investing company. And we've actually had a number of discussions around sort of like ethical investment where basically it's the investor may want sort of pretty much everything and have their cake and eat it too, right? And I'm just saying that because obviously we had 4 investors, but there is this theme or discussion around a lot of investing companies who are concerned about that, that investors will have a look at your books, have a look at your due diligence, and then maybe not go ahead with it. But they've incurred significant cost to the investee company, as well as time and the stress. I mean, it's really stressful getting, money into your business. So that whole cap raise thing.
Yeah, that's pretty. I think that's something that's quite not talked about very often. That your staff will need to help with due diligence, and that's not something that they do every day. They won't be used to it, and it will take up a lot of time, a lot of the time of your staff. And at the same time, as they are answering like 50 questions a day or whatever, they have to kind of keep the business running. So it can be tough, depending on the size of the raise and kind of how demanding the investor is. In that particular example, I'm not too sure what they could have done there, because it was just quite unfortunate that part was not caught in the initial due diligence. It was quite a late stage in the negotiations. But often it is these types of issues they are caught in due diligence stage, which hopefully will kind of prevent a lot of the costs being incurred before they decide to pull out. But that's just the nature of some of these transactions. Going back to your question of, what kind of examples of investors just not gelling quite correctly with the founders' expectations, there are so many examples. I mean, one quite somewhat common one maybe is that you have a passive investor that just kind of is along for the ride. Maybe they take like 2 or 3%, maybe 5%, but they're just not very responsive. I mean, it's fine if they don't have like much voting power, but if you need to pass like a unanimous resolution and it's quite urgent and you need to kind of like wait for them to respond before you can do so, it gets really just administratively very annoying.
Yeah.
So I mean, that's kind of one of the more minor ones, but it's a relatively common example I see. Another one could be just your vision for the business not aligning with the vision that the investor has. Because if they are a PE fund or maybe a VC, maybe they have a certain kind of like shelf life or kind of horizon where they want to exit and make back a multiplier on their investment. And you might not be ready to kind of sell the business by that point. So it's kind of important to align kind of your timeline and your goals. at the outset. Otherwise, it can get quite quite messy. We had one sale of a business where the founders, well, not all of the founders were kind of on the same page, and the PE fund wanted to exit.
You're talking about at that VC or private equity level, right? They're saying their objective, usually for a VC or private equity firm, they're very sophisticated investors. They're looking for probably a 10-year forecast or timeline as to when they're going to invest and when they're actually going to get their return, which is quite reasonable, actually. I just kind of raise it because it's another thing for founders to consider and I've seen this come up where at the friends and family level, they've got unsophisticated investors coming in, and their expectation is kind of like share stock exchange where you can put in a short term and get your dividends back within 12 months. When can I get my money out? And the founder's sitting there going, that's not how this rolls. Is there anything like just horrific where I guess I want to get to the point of, is there any horrific sort of gotchas or watch out for this when going into that investment sort of stage where you're just like, it could bring your company down if you're not careful?
I think I'll let you talk to this because you're the detail a lot better than I do, but there are obviously regulations or legislation that companies will need to comply with in terms of, say, cap raise. And that's the Financial Markets Conduct Act. So that's to kind of protect your mums and dads from, people going out and saying, hey, why don't you invest in my company because you could make however many, X times return or whatever it might be. And so from a legal perspective, you need to understand or need to know that if you are going out to do these raises that, you do, you're not falling foul of the FMCA. Like you probably go into a bit more detail.
That's right. So hopefully, the first step, I guess, in the kind of scenario that you described is probably just make sure everyone, this is communication, and make sure everyone knows what's going on, everyone's expectations. I wouldn't say, encountered a scenario where that's happened where it's really bad for the company. In those scenarios, it's really, if it adversely affects anyone, it's the investors. So I would say be aware of what's in your shareholders agreement. And one of the cases quite similar to the situation you described that I've encountered, some of the investors who weren't willing to sell were forced to sell because those who wanted to sell invoked the drag-along clause, which means that if a certain majority of the shareholders decide to sell, they have the ability to force everyone else to sell along with them. And some of them got very angry that they had to sell. Some of them had been with the business since the very inception. They didn't like maybe who they were selling to or whatever, but they were forced to sell because of that clause in their shareholders agreement. And it's a very standard clause. It's there so that the private equity firms or investment firms have certainty that they can exit when they kind of their investment mandate requires them to. And it might be, I've seen a lot where it's shorter than 10 years, where maybe it's 5 years or whatever their turnaround time for that investment is, but they need certainty that they can exit. So it's quite a standard clause, but you need to be aware that it's in there and what you're getting yourself into. If you're a dissenting opinion in the business, sometimes maybe just have kind of no choice because it's very difficult to prevent an investor from coming on board if you just have a very tiny fraction of the company. So, the only I guess solution then is probably just to ride along and see what you can get out of it at the end. I wouldn't say that it's going to be disastrous for the business, because hopefully you've kind of gotten the advice to kind of keep the level of control required to keep the company going in the direction that you want it to go. And that's kind of the back and forth and the negotiations when you kind of take on an investor. How much control am I willing to give up? And can I still direct the company in the direction that I want it to go? And if you've kind of received good advice and kept that level of control, then your company should be fine until you want to exit.
That's probably a key point. I think a lot of people think the first thing they think of when they're giving up a shareholding is like, oh, how much money am I potentially losing by doing that? But in the much nearer term, it is much more about control, isn't it? I would assume that our listeners today are like, this is great, but lawyers are of a high profession. You have all this expertise. How would they actually? What's the smartest way to engage with a legal firm and in the most pragmatic sense?
I think every firm is different in terms of how they operate. The feedback that we've had from our clients is that you guys are just normal people, and that we're not intimidated. We thought we would be intimidated because, we'd be seeing these, lawyers suited up and whatnot, and, we're not like that. We play in the tech space. We kind of try and operate like a tech company. We dress for our day. We don't have, I think the last time I wore a suit was, I don't even know when. But it's just one of those things where we try not to be intimidating. Like if a client or a new client comes through the door, I'll be like, hey, let's have a chat, and you're not on the clock. I just want to learn about your business, and give them an hour or two, have that chat with you to see if you can actually relate to this person. Are you comfortable? Can you build rapport with this person? Could you actually have a drink with this person? It's building a professional relationship, but also being able to sort of communicate with them, because that's the most important thing, I think, which is you're their trusted advisor, so you need to be accessible and transparent, I think. Yeah. And I think that certainly helps, because you can't have someone who's not wanting to tell you stuff because, oh my gosh, I'm always on the clock. Or sorry, she's always on the clock. We just need the information so that we can basically help you with your business or to do the deal or whatever it might be.
Yeah, I think so. And the other thing about, I guess, choosing what kind of lawyers to engage, it is probably someone who has kind of specialist knowledge or experience in your industry. At a certain level, you kind of expect good quality kind of like legal work from all lawyers of their well-known firm or something. You can kind of just expect that they know the law. But in terms of specialist, do they have specialist expertise? And obviously, kind of overarching over all of that is, can I work with them? Are they easy to work with? A lot of the larger kind of like firms and organizations in New Zealand, they don't have a really specific list of like factors that they need to kind of tick off in order to engage a lawyer. Often it's just a quick conversation of, is this person good and are they easy to work with?
And I think to your point, Calvin, about the expertise, because I think it's more than just do they know the law. What I've always experienced is that I'm using my legal advisor for what else have you seen, because they're walking into the room. I think we talked about this earlier as well. I as a founder have only my experiences, or maybe I've gone to events, or maybe I have a mentor, so very limited extra knowledge and understanding. I'm in a bubble, whereas my legal advisor is potentially working across 20 companies in the special expertise of technology, and they're actually bringing in all their different models and ideas and things that they've seen. Well, this worked and this didn't. That's what I've often gone to them for. It's like, I need to do a deal that's structured like this. Have you got any other ideas that will make it better? And they're like, yeah, actually, you could do X, Y, and Z.
Yeah, no, that's exactly right. I mean, it's kind of like if I were to use accountants as an example, then if you have an investment property and you want to do accounting on that side, you would probably go to an accountant that specializes in property management, rather than just a general accountant. It's kind of like that.
And we've been asked some pretty random questions, or can you structure it this way, or how could you do this, or whatever it might be. And because we've just done this time and time again, kind of know where to look.
Yeah.
And this is not necessarily in the say cap rate space. It could be we have a lot of multinational global tech companies coming in saying, we want to provide this service in New Zealand. How do you do it? And we're like, well, you could do it, but you're going to run into issues with the Privacy Act or the Medicines Act if you've got a medical device which is has a lot of technology behind it, or whatever it might be. So it's just knowing how to get around the particular the laws.
Yeah. And I think sometimes we get clients who come to us with quite novel ideas that kind of no one's has kind of ever tested with the law before, and those are the times when you kind of really want a specialist. We're able to help them, but obviously we tell them, hey, you're the first one. Let's this is the process to test it, kind of thing.
And there are a lot of edge cases, right, where it's like, wow, I don't know how you're going to fit into this legislation, but the legislation is so vague, or they have not thought about it before, that we think you can get around it. Yeah. Or obviously there might be a risk here, but no one has thought about this sort of particular AI device when the legislation was drafted in the 90s or even the 80s or whatever it might be. So that's what we're up against. So that's why we like our job, because it's kind of like finding a solution for a problem.
I did like that approach that, that's an example of how your customers are approaching you. They're saying, I want to achieve X, Y, and Z. They're not saying, I need this piece of document written up. They're actually just saying, I've got a strategy and I want to achieve this. And then it's the creative work that you do around that to problem solve. I've said this to a lawyer before, that I felt like the law is kind of a living, breathing thing. It's not like mathematics where it's, 1 + 2 = 3. That law is way more creative than that.
Yeah, in a sense, that's right. I think the best way to approach it is tell us what you want, and we can kind of hopefully kind of find a way to make that work for you, rather than, I know that we need, I've seen people do this before, I know that we need X document and X structure, but it might not be the case for you. And if you tell us, just let us know what you want, we can hopefully make it work. Because as you say, that it's not exact science, so it's more of an art, I think.
It is an art. That's a good word, an art. Yeah. Ed and Calvin, it's been an absolute pleasure having you both here. You've shared some really in-depth knowledge that I think is going to be really valuable to founders out there who are first starting their journey of even just engaging with legal advice, or they're actually on their investment journey. And I hope that this is actually, one, you've enjoyed it, and two, that our listeners have enjoyed learning from you. So thanks very much for coming along.
Thank you very much.
Thanks, Shona.
I'm Hussein Al-Badri, producer of These Three Things. This part of the podcast is called The Three Learned Things. Shona and I wanted to briefly reflect on the 3 key insights we got from today's episode, which is brought to you in association with Callaghan Innovations Upskill Products. These products are designed to help startups uncover and acquire the skills they need to succeed. So Shona, should I kick off with the first insight that we got from the chat with Edwin and Calvin?
Yes, please do. Go for it.
They said something around everybody being cautious that getting their IP ripped off is their highest risk. And Edwin talked about the fact that IP rip-off is not as much of a high risk as you think it is. The real risk is actually in things like your data security, your data privacy, and your ability to protect things like customer data and your ability to prove that as well. That was super fascinating for me. I've always talked to companies and that is the first thing on their mind. IP protection is the first thing on their mind. I guess it makes sense, but it is kind of refreshing to hear it directly from the lawyers. From their perspective, your biggest risk is how well you look after your customers' data and how good your cybersecurity posture is in your product.
Truly fascinating, because I agree with you. I'd probably say that most founders are quite technical because that's how we can get our product to market as a prototype, right? So at least one founder is usually technical and that's their baby, right? And they are really deeply concerned about protecting their IP, everything they've made up and thought about the world. And then it turns out actually it's your data security in this world and in this environment. And I often actually come across CTO founders that would kind of just dismiss it as if it's a box checking, activity. And it turns out that they're seeing it as a high risk, and that's where the litigation is coming in.
Super fascinating. What did you learn?
So from my perspective, it was not something I've learned so much, but it was something that was just because I had learnt it through my career, but I love the way Edwin put it. He said it's about being pragmatic. I couldn't put a word to what I was looking for when I was seeking those professionals that represent me, but those that are truly frustrating and have cost me a fortune are the ones that dot every I, cross every T, and they're not pragmatic. And that was the word that he used. You're looking for someone who's pragmatic. And he's absolutely right. I think anyone who expects their lawyer to dot every I and cross every T, they're just asking for big bills and to have slow deals being closed. Whereas you want your lawyer to say, what do you want? What are your risks? What is your objectives? And how do we get this deal closed really fast for you? And I just love that because he just succinctly put it. So a huge thing that I'd love for people to take away from this.
Yeah. I really loved how he talked about the types of things that he would ask clients and the fact that he would, getting interested in their business and what their business is about was actually a big part of the cycle that they go through. So they build that relationship with the founder and that's part of how they get involved in these companies. And I think that was really refreshing to hear because I think a lot of founders also get put off by lawyers because lawyers usually mean, dollar signs. And so, finding people who are pragmatic and who are invested in understanding your business and really customizing the rules of engagement to your risk profile is...
Yeah, absolutely. I couldn't agree more. So, Hussein, what do you think was the last big thing for you that you've taken away from today?
Yes, so something that the team talked about when we started talking about capital raising was the fact that there is nothing wrong with not getting investment. Everyone thinks that investment has to be the number one goal and it almost becomes a self-fulfilling prophecy. And they talked about the fact that, they've been with plenty of organizations who don't have investment and they're actually okay with that because there are some pros and cons when it comes to raising capital. And if you don't have to do it, if you don't need the cash or you don't need the expertise, then there's other ways of kind of pursuing that. And I found that really refreshing as well.
No, that was a really good outtake from what they've said. Obviously, people feel like getting investment capital is the fastest way to scale and their success, but with the pitfalls that come with it and your responsibilities and, the way you have to deliver back to the shareholders upon your promises can be really challenging. And I think there's got to be a bit more of an open mind as to how else you can raise capital. So if your strategy is to raise capital and it doesn't work out for you, have a couple of other options up your sleeve. Like, are you approaching your customers to see if you could have a business model where they're upfront paying you for what they need? Or is there a debt loan? Or is there just other types of financing that you can contribute to get yourself out there and get your prototype in the market rather than going, well, investment or bust, really. That was a great outtake. Can you do me a favor? If you like this episode, can you hit the subscribe button? It really makes a huge difference to us, and it means that we can continue to evolve, grow, and bring more insights from a larger variety of guests. Thank you for listening to These Three Things. Our podcast is fueled by our passion and admiration for startups and the courageous people who create them. A huge thanks to our wonderful listeners and guests, my producer Hussein Al-Badri, our sound and visual crew, Elisa Grishkova and Carl Butler, and our sponsor, Callahan Innovation, who are just as committed and passionate about the ecosystem as we are. Tune in next week for another episode of These Three Things.